Hello, my name is Robert Goodwin, and this is Law on the Line. I'd like to introduce my guest for this session, and Atiya Aftab. Is that correct?
Yes, it is. Thank you.
All right, good. And I know that you're a practicing attorney and also an adjunct professor here at Rutgers University in New Brunswick. Is that correct?
Yes, I am.
And Department of Political Science and Middle Eastern Studies program. And one of your areas of expertise is teaching Islamic law. You're also, in your spare time, the co-founder and chair of the Sisterhood of Salam Shalom, an international women's interfaith organization, and a member of the Islamic Society of Central Jersey. Mm-hmm. I would like to welcome you again.
Thank you so much. Thank you so much for having me.
I think we're going to have an interesting program. A little bit out of the ordinary. We're not going to be talking about, tort law fall downs and, car accidents. We're going to talk about something which is perhaps a little more esoteric, but I think it really reaches out and deals with the fundamentals of the sources of law. Mm-hmm. And I would like to ask you, since you are an attorney in the state of New Jersey, correct?
Mm-hmm. Correct.
Licensed to practice.
Yes.
To what extent is there an intersection of what is Muslim law, Sharia law, mm-hmm. and civil law in New Jersey? And as part of that, is there any rational reason why people fear that word Sharia law?
Great way to start. Thank you so much, Robert. And I guess the first thing to say is let's talk about terms. And I say this in class on the first day of class when my students come in, and I say to them, what do you think of when you hear the word Sharia? And some of them will say beheading or, some very extreme things, honor killing. And I want them to feel open that they can say whatever is in their head when they hear the word Sharia. And when we talk about, well, what does actually Sharia mean? It's the reaction is kind of surprising. And that reaction is because the word Sharia in Arabic means simply the path to happiness in this life and salvation in the hereafter, meaning the path to God. And the path to God, since it's religious law, is not just about absolutes, about what's legal and not legal and illegal in an understanding of how we understand law, but it's also ethical guidelines. So kind of what should you do and what shouldn't you do, right? Which is different. It's much broader. It's a much broader kind of path of understanding
Than a particular statute.
Exactly. In other words, you can't drive over 55, but maybe you shouldn't drive over 45 in a certain area. So I would kind of parallel it to that. So what is Sharia law? Sharia law is that path to how a Muslim can live an ethical and happy life and achieve salvation in the hereafter. And how does a Muslim determine that? Using the sources. So what are the sources of law in Islamic jurisprudence? It's the Quran, that's with a Q, and the Quran is what Muslims believe to be the word of God, that was a divine word of God that was revealed to the Prophet Muhammad, who is in a long line of prophets starting from Adam to Noah to Abraham to Joseph. This is the tradition in Islam. And that was revealed to the Prophet Muhammad about 1400 or so years ago. And that is the major source of the law and ethical guidelines. And then the second source is actually the life of the Prophet, what he said, what he did, what he recommended, how he lived his life.
And what is that second source called?
That second source is called the Sunnah, S-U-N-N-A. And the Sunnah is, it's not compiled into one text, whereas the Quran is compiled into one text. It's about 6,000 verses. Whereas the Sunnah, or the examples of the Prophet, the sayings and the doings of the Prophet, are actually in multiple canonical collections. So what do we, as lawyers, we think, oh my gosh, like multiple canonical collections, what does that mean? That means that there has been, from the inception of Islamic law, different understandings of how to be an authentic Muslim.
Yeah, I have, as a definition, if I may look at my
sheet,
sayings and deeds of the Prophet Muhammad,
right.
And they're compiled.
Right.
And how were they compiled? What's the history behind that?
Sure. So it was one of the original, we call them sciences of Islam, Islamic sciences, was that determination of how do you record history. So in a sense, the Sunnah is a way of what we would understand as Americans. How do you understand hearsay? So it's somebody, an individual, a narrator, saying, I heard that the prophet said this. So how do we authenticate that? So this, the science, the scholars of this study over about 1,200 years ago came up with methodology to determine the strength of a narration. Was the person who was narrating, were they reliable? Were they an honest person? Was it physically possible for them to hear that the prophet said X, Y, and Z? Did they live at the same time? So they developed a whole methodology in science to weigh and determine whether or not some of these traditions were authentic or not authentic or weak. And all of these sayings and doings have been, as I mentioned, have been compiled into canonical collections. So let me give you an example.
Sure.
Because that's probably the best way to do it. An example is that in the Quran, there's only about less than 7% of the Quran, of those 6,000 verses, have to do with the law. The majority of it is just guidance, be a good person. God is one, issues of monotheism. So if you're talking about only 7%, right, that's a small, tiny percentage of the entire text. So what you have is the Sunnah. When you look at the Sunnah with the text of the Quran, it fills out the areas that are missing. So for example, laws with respect to inheritance. There is very, very clear text about how money should be transferred from the deceased.
And that would be in the Quran.
That is in the Quran,
Correct.
but there are certain things that are supplemental. So the Prophet himself indicated, grandparents are not mentioned in the Quran, but a grandparent should also inherit. So this is how you have supplementary evidence connected to the evidence that is in the Quran. So that's how these two texts kind of work together.
And that would be in the Sunnah. That would be found in the Sunnah.
Right.
Now, is the Sunnah a document or a compilation of text that is prepared, you said approximately 1,400 years ago? That would be contemporaneously with the Prophet Muhammad.
It was actually 200 years after, so about 1,200 years ago.
Is that an immutable doctrine, or is it, does the Sunnah change over time based upon interpretation?
Very good question. So
Thank you.
the texts don't change. The texts are immutable. It's the interpretation of the text that is what gives life to the language. And there's a great story, I think it's a great story, this was the son-in-law of the Prophet who actually became the fourth caliph, or the fourth leader of the community after the death of the Prophet. His name is Ali. And he was the story takes place while there's a battle going on in the community, and his opponent says, we're going to resolve this battle by the words of the Quran, right? The Quran is my text. And so Ali says, well, here it is, there's the text, puts it on the table and says, let it speak. And the lesson from that is the text does not speak without a human voice, without a human interpretation of that voice. And so Islamic law is the human understanding. The word in Arabic is fiqh, F-I-Q-H. It's the human understanding of what God intended. So it's inherently fallible and mutable, but the text itself is not.
I see. So the fiqh, and I have here as my definition, the practical body of jurisprudence. Mm-hmm. Does that's subject to mutability, is that correct?
Absolutely.
Contemporaneous mutability, or is that again fixed in time, the fiqh?
So I would say that it's fixed. There's laws that were established 1,200 years ago, 1,000 years ago, 50 years ago, 100 years ago. That does not mean new law can be established today. But there's value on precedent, just as we have in our tradition. There's a value on precedent. So you will have precedent established, and you can have scholars today look at that precedent, look at the text and say, you know what, even though there's X precedent here, the evidence supports a decision that's contrary to that precedent. Or you may have a scholar saying that precedent is solid, and perhaps there's a new issue that needs to be resolved, may be in line with that precedent. So you still have the responsibility of scholars to look at the original text, understand precedent, and come up with their own rulings on issues.
Similar to the development of the common law.
Yes.
And we talked about that in our preliminary discussion about how the common law develops, and looking at a document which is our first, for example, our Constitution,
Right.
our 10 amendments, and perhaps the language itself is written and it's interpreted. And we talked about the originalists versus somebody that would against the other approach, which would be looking at it from a contemporary point of view. Explain that in relationship to something that we can understand relative to our Constitution and,
Sure.
first 10 amendments.
Sure. So just as we have in our tradition of how scholars have looked at the Constitution, and we use an example of whether it's the Second Amendment and the right to bear arms, or the Eighth Amendment and cruel and unusual punishment, that how we read those texts today, those amendments today, we can say, well, what was the original intent? What was the intent of the Founding Fathers? What was written in the Federalist Papers? There are those scholars who say, let's look at the exact literal language that's written in the Constitution. So you have like a Frederick Douglass, who wasn't a justice, but said, you know what, slavery doesn't make sense in the Constitution because the Constitution doesn't talk about slavery, right? So using a literalist kind of perspective. And then you have like a Justice Brennan, who said, let's look at the spirit of the law when he talked about cruel and unusual punishment. Right? It doesn't matter what the definition of cruel and unusual punishment was 200 years ago, but what does that mean today? Right? We recently just had, I think Texas just had a recent execution, I think just a few days ago, using gas as a new method of execution.
Of execution, yes.
And is that, and do we, how do we look at that under the auspices of cruel and unusual? And so when looking at Islamic law, you have similar interpretive communities. You have interpretive communities that will look at text. For example, the cutting of the hand as a punishment for theft. Is it a literal cutting of the hand? How was cutting of the hand looked at 1400 years ago when the Quran was revealed in a society where the biblical punishment for the cutting of the hand for theft was crucifixion? So in other words, the cutting of the hand at that time was a very liberal punishment.
Less extreme,
Less
obviously.
extreme, right. But we think about it probably in 2024 here in New Jersey, New Brunswick area, as a very harsh punishment, right? So it depends on, and so you have scholars that will say, well, was it literal? Was it prescriptive? Is it something that is more, what's the spirit of the law? Is it cutting off of conducting that kind of an act of theft? And these are reasonable debates and questions for scholars to look at when they look at the text and talk about. So it's very similar. It's very similar.
Where would that debate take place, though? Would that be as part of the fiqh, or?
Right. Yes, the scholars who are engaging in the process of looking at the text, looking at precedent, and issuing opinions. And opinions in Arabic, it's called a fatwa, or a legal opinion, which are non-binding.
I see. So what is the intersection of that jurisprudence, if you wish to call it that, and our law in the state of New Jersey based upon our statutes, our common law, our original New Jersey, for example, state constitution, where where our law flows from?
Right.
What is the interrelationship between the two?
I know you had asked me that question. What's interesting is that sometimes you will have this intersection. So we went from 1400 years ago to today. So for today, for a Muslim living in New Jersey, for example, how does this matter? How is this relevant to their life, and how does this matter, quite frankly? And I would say probably the most common way it matters is when we look at family law, and we look at the institution of marriage and divorce as well. So when I say that Islamic law it's religious law, so not only is it, again, the legal parameters, but it's ethical parameters. So a Muslim who's a practicing Muslim would want to make sure that when they get married, and I happened to get married in the city of Piscataway, actually, so I had to go to the municipal court here, get my license, and make sure that the officiant of my marriage was able to get a license, was, as an official officiant. But also, since I'm a practicing Muslim, wanted to make sure that it was done in accordance with Islamic law. So you have this kind of marrying between what's the civil requirements of marriage as well as what I felt and other Muslims who are practicing want to make sure that they're making, that they're following their religious responsibilities. And so what are those religious responsibilities?
And how are they enforced or interpreted?
Sure. So basic requirements of a Muslim marriage is considered to be a solemn civil contract. So it's a civil contract, but when we say solemn, it means that there's a religious air to it. It's a promise. You're promising God, I will, I'm taking on these rights and responsibilities when I'm entering into this marriage. And it requires 2 witnesses, and that's it. That is all it takes to have a valid Muslim marriage. There is one other factor that's important in a Muslim marriage, and that is the husband is required to give his wife a gift, and that's called the bridal gift. It is sometimes called the meher, M-A-H-R, the meher. Sometimes it's called the sadaq, which comes from the word also gift and trust. And so that's a requirement of a Muslim marriage. And it's not consideration as we understand as a contract, but it is a gift. And that gift is set forth in a couple of places in the Quran. So it's actually in a very clear text in the very fundamental source. And how that has been interpreted. So now we have that as a requirement for Muslim marriage. So when a Muslim marriage breaks up,
equitable distribution.
That's the question.
Okay.
And in Islamic law, there's no such thing as equitable distribution.
It's just for the benefit of our audience. What is
Yes.
equitable distribution as an attorney here in the state of New Jersey?
So I'm not a family lawyer, so I don't want to mess this one up, Robert. But
I'm sorry.
equitable distribution meaning a reasonable distribution between the parties.
Right, of the assets acquired during the course of the marriage.
During the course of marriage, correct. In Islamic law, and that's something that actually diverges from Islamic law, because in Islamic law, a woman's wealth is her own wealth. So her husband does not have any right to her wealth after they're married.
And that would be independently owned property?
Yes.
Okay.
And so we don't have that concept in America. So in some sense, Muslim women in New Jersey and in America are actually at a disadvantage, can be at a disadvantage if they have their own wealth, because their husband has a right in it in America. But under Islamic law, they don't have a right to that. So that's a difference.
Yes, it is.
That's a difference. A Muslim husband has the responsibility and obligation to support his wife and has a responsibility to support his children. So those are some of the rights and obligations in a Muslim marriage. And like I said, this bridal gift. And if you see if those who are interested in this intersection between family law, Islamic law, and family law, if you look at the case of Odatala versus Odatala, and it was litigated, the plaintiff's attorney was a colleague of mine, Abid Awad, who specializes in family law as well as Islamic law. And in the issue in that case went up to the Supreme Court.
It's O-D-T-A.
O-D-T-A-A-L-L-A,
Okay.
Odatala versus Odatala. It was, the issue was this bridal gift, the meher, was that considered to be a Muslim, was that a prenuptial agreement? Was the Muslim marriage contract a prenuptial agreement or an actual simple contract? And that was litigated all the way to the Supreme Court.
Was that Judge Malla who made the original decision?
I looked that up after we talked, and I don't think so. I
Okay.
think Judge Malla was an attorney at that time before he became.
And what was the holding in that decision?
The holding in that case was that a Muslim marriage contract is not a prenuptial agreement, because a prenuptial agreement has its other standards. You have to have counsel, declaration of assets.
The statutory was modified relatively recently by statute, and it requires the formality, especially the witnesses, in writing, of course.
And that's not what is required for a Muslim marriage contract. So I think it was the right decision. I think it made sense from a perspective of Islamic law. But this is how you see these overlaps between religious law and civil law, and how they are dealt with in our system. And they're not contradictory. They can work together. You can live a practicing life, an observant life in what religion you practice, as well as a citizen of this country and a citizen of the state.
And so the gift that we're talking about, not Sadiq, what is it called?
Meher or the Sadaq.
Okay, it's Sadaq, the Meher.
Mm-hmm.
Would that be considered a premarital gift, or is that considered a gift of the
marriage?
Gift of the marriage occurring during the marriage?
Correct.
So, and if it occurs during the marriage, then it would be subject to our law of equitable distribution.
Under New Jersey law.
And
yes.
that was the holding of the case before the Supreme Court?
That was it. Wasn't an issue of it. Yeah, that
wasn't an issue of the case.
It wasn't. Yeah, that wasn't an issue of the case.
So even though under Muslim law, that would be an asset that would belong to the wife, but not necessarily here.
Exactly.
And in a divorce in the state of New Jersey.
Right.
And
so in other words, a Muslim woman in some ways has less rights.
In that instance, yes.
Yeah.
Now, many people think that, perhaps, and most likely incorrectly, that there's some usurpation then of religious law over the common law. That's a false narrative, isn't it?
Sure, that's a myth. I mean, it's a false narrative because ultimately you can engage in a contract, a neutral contract with anybody, and this would be looked at as a neutral contract, and a simple neutral contract for which if you make a promise and I make a promise, we're both held to that standard.
And you know, in our preliminary discussion, we talked a little bit about estate law and how that may be impacted, the traditional common law and our statutes, and we have a significant number of specific statutes regarding the estate law in the state.
Right.
We have, I think, 3 volumes of the New Jersey statutes annotated, Title 3B, I believe. So what are the distinctions and how are they melded, if you will?
Sure, and that's a difficult question because if you die intestate, you die intestate, and you don't have, your estate has no control then over distributing assets as per Islamic law, just off the bat. So and it's not just the distribution, but it's also the will of the decedent. So if the decedent doesn't indicate perhaps that they want to be buried in a Muslim tradition, depending on who the survivors are, may or may not follow those wishes. So we always say to our in our community, to our Muslim families, make sure you have a will. You want to make sure that you are, if you're a practicing Muslim and you want to be buried as a Muslim, make sure that you have your will. You don't know who's going to survive you and who's going to be able to perform your religious rites. Also distribution. In Islamic law, very generally speaking, because it's also, you talk about volumes in NJSA.
Right.
There are many, out of those 7% of verses in the Quran that are legal, a good percentage of them have to do with
estate distribution.
And it's very technical. But generally speaking, 2/3 of a Muslim's estate is spoken for in a way that the decedent cannot change. So in other words, your children get a certain percent, your spouse gets a certain percent, your survivors get 2/3 of your estate that you have no say over. That's already set forth in the text, in the Quranic text.
So if you wish to practice the Muslim faith, would you recommend anyone listening to this program have a very specific will that would provide for those specific provisions?
Absolutely, absolutely, in accordance with Islamic law, absolutely. That 2/3 of one's estate, you do need to have somebody who has knowledge about how those percentages fall out, and the fact that only 1/3 of the estate does the decedent, or no, not the decedent, the one who's writing the will. You're not a decedent yet,
no.
But the individual has the right in that 1/3 to donate in a way that's of their choice.
Distributions that may be outside of the immediate family.
Exactly.
I see. And that is perfectly enforceable.
Yeah, absolutely. And that's what I mean by this. That you talk about what's the cross between the Islamic law and New Jersey law is that would absolutely be appropriate.
Right. But don't expect that if you're a practicing Muslim to happen
if you die intestate.
If you die intestate, exactly. So that's something I think a good pointer, a practice pointer for people to get out there and get a will.
Get a will. And that 1/3, Muslims are encouraged in that 1/3 to give to charity. So whether it's setting up a charitable trust, whether it's donating to your alma mater, whether it's donating to an orphanage, whatever it is, but that 1/3 is encouraged to be a donation to something more than, an individual.
And is that found in the Quran, or is that found in the writings, in the Sunnah, or both?
It's both. It's both, but definitely the 2/3 distribution is set forth with very much specificity in the Quran.
I see. Now, you also mentioned, not in our discussion preliminary, was the about business law and how what we called Sharia compliant laws or loans. Explain that to our audience in general.
Sure. So Muslims are to lead an ethical life. Muslims are encouraged to live an ethical life in all of the aspects of their life. So in their life, in their family life, which we touched upon, as we pass, so in our estates, and also in our business transactions, in the work that we do, to live an ethical life. And part of living an ethical life in Islam is to not take advantage. So the poor, the rich should not take advantage of the poor. So this idea of, if I have $1 million and someone doesn't, and I want to loan them money, I should not extract usury from them. And that's part of an ethical life. So the payment of usury, and we call it usury because there's debates about, and there's actually debates in the Muslim community about whether that is interest or is that usury. Is it, right? Because there's a difference in English. And the word riba in Arabic means increase. So if I loan you $100, I'm not supposed to charge you more than $100. However, $100 today is not the same as $100 in 5 years, right? So then there has to be some room for that. So
an adjustment.
An adjustment has to be made. So the Quran and Islam doesn't say there's no adjustment, but it shouldn't be that I am taking advantage of you. I should be ethically sharing of wealth. So there is a whole business of Sharia compliant loans, of Sharia compliant investments, and that's something that's it's
basically ethical investments.
Absolutely.
Well, I got the 1-minute wrap-up warning. So what would you like to impart to our audience that perhaps we did not touch upon in this very, very vast discussion?
Right.
And just trying to make some practical tips or statements regarding this intersection.
Sure. So, I mean, we're talking about a subject, right, in just a few minutes that is a course that I teach in one semester, which is really doesn't give also value to one of the greatest accomplishments of the Islamic civilization was their corpus juris and this, Islamic jurisprudence. And there are 55 Muslim majority countries. So what we're talking about right now is just kind of the essence. And it still matters to Muslims today, because if you are a Muslim and you're practicing your religion and you want to live an ethical life, you want to live a life where you will be happy on this earth and achieve the path to God in the hereafter, you want to make sure that everything you do in your family life, in your marriage, if you're divorced, in your estate, in your economic interests, in your work, that you are following those ethical guidelines, and that they are not in conflict with our life as Americans in the United States under New Jersey law. In fact, sometimes there are, like I said in the example of women's.
There's a benefit.
There's benefits, and sometimes there's some losses, but there's no contradiction. And this idea of creeping Sharia and that Sharia is something scary is really a myth. And everybody get your will.
Right, yes. And I would say it's a myth that has been exploited, unfortunately.
Yeah, there's political reasons for that.
Yes,
yeah.
And there are, and that's beyond the scope of our show.
Absolutely.
Well, I think we've wound down to the last few seconds, and I again like to thank you very much for being my guest and for Law on the Line, and I think our public will benefit. And I just want to shout out on this show, take a look at the Law on the Line Facebook page and look it up on the Bar Association website. And you can see all of the shows that we've done over the last few years. And there's a nice catalog now that we've developed. And
thank you so much.
You're very welcome.